Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. We have created a series of videos on the arguments made by senior advocates, namely Mr. Kapil Sibal, Mr. Gopal Subramaniam, Mr. Zafar Shah, Mr. Rajiv Dhawan and Mr. Dushan Dave previously. Today in this video, we'll be covering the arguments made by senior advocate Mr. Chander Uday Singh, who is appearing on behalf of Mr. Mohammad Yusuf Tarigami, former MLA and CPIM leader. Mr. Singh started the arguments by saying that he would only focus on the J&K Reorganization Act. He said that the bill was presented by the President and was tabled in the Rajya Sabha and was finally passed by Lok Sabha on August 5, 2019, and then it was tabled in Lok Sabha on 6 August and simultaneously passed by the Lok Sabha. He said that UTs can be interchanged with states under Article 3 as per the 18th Amendment, and the 18th Amendment was not applicable to J&K on 5th of August 2019. He added that Part 1 is to be read conjointly, and when read conjointly, no power is provided under Article 3 to convert a state into a UT, notwithstanding two explanations. Mr. Singh said that the Reorganization Act, apart from 370, is important for the people of J&K, and if this interpretation of Article 3 is upheld, then it is the thin end of the wedge for democracy and federalism and the country as a whole. He said it's because if any party is in power at the center, as well as a state, it can just convert the state by a simple majority in state legislature and simple majority in parliament. After this, he took the bench through the judgments pertaining to judicial scrutiny required for proclamations imposing president's rule. The CJI posed a question at Mr. Singh and asked if the conversion of the state into a union territory can be separated from the abrogation of Article 370, in response to which Mr. Singh affirmatively said yes and told the court that these two are separate. The CJI posed another question. He asked, and I quote, "Was there a peculiar constitutional history attached to the creation of UTs, and does that category remain frozen now?" He added to the question and asked, and I quote, "Your argument will be in this way: what is the history of creation of UTs? Does that category remain frozen in the sense that you can convert a UT into a state but not a state into a UT?" Mr. Singh replied and said that it is what has happened historically, that by 4th August 2019, there were 7 UTs left in India, and all the other UTs, once they became viable units, they were converted into states. Later, he made a mention of how the splitting of the province of Bengal by Lord Curzon in the year 1905 was not welcomed, and Lord Hardinge was compelled to rescind the move. He said that this experience led to a declaration by the British Parliament to confer greater power on the provinces of India. Following this, Mr. Singh underlined the history of converting a state into union territory by referring to Government of India Act 1919. The CJI said that looking into the position of the Government of India Act and how it transformed into the Constitution can give an idea of how UTs were created. And Mr. Singh said that he would show the progression in the court. The bench referred to the Constitution as it existed on 26th of January 1950. And Mr. Singh said, the point is that right from the 1919 Act, the progression has consistently been towards greater self-governance in the form of statehood. He submitted that the conversion of a state into a union territory, if at all it could be done, could only be done under Article 368 because it clearly impinges on at least 6 to 7 provisions. So it would require both special majority and ratification by more than 50%. He also mentioned that for Ladakh and J&K, the exercise which was done is an exercise outside the purview of Article 3, even if it was rightly done. Mr. Singh made a submission that history of Article 3 and 4 generating from 1919 and 1935 Government of India Act show that the power to alter boundaries or change names, etc. was always used to increase self-representation and democratic self-government, and there was no case of retrogradation. He informed the court that he has set out a chart of how various territories changed from state to UTs to full states. He said that some small non-viable territories have remained which aren't viable as states. Stating an example of Dadra and Nagar Haveli and Daman and Diu, he stated that even they have been made into one UT. He also made a mention of Article 1, 2 and 3 and other articles and correlated the same with the issue in question. In order to check the same in detail, please go to our website and check out the live updates. That was a summary of the major arguments made by senior advocate Mr. Chander Uday Singh. I'm your host Nazarat Fatima, and I'll be back with another video where more such arguments and contentions will be covered. That's all for today. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube, and don't forget to press the bell icon for notifications. Thank you for watching.